Hey there. Friend, if you carry, own, or even plan to buy a gun, buckle up. October 2025 didn't just rattle the news cycle. It rewrote the rule book for every firearm owner in America. 10 massive court rulings just hit back to back, and they're shaking the entire system. We're talking about national reciprocity through the courts, ammo restrictions getting nuked, the ATF taking hits from every direction, and police departments scrambling to rewrite their playbooks. Whether you're a weekend shooter, a competitive marksman, or a concealed carrier, what just happened changes how you live, travel, and protect your family. So do me a solid, hit that like, subscribe, and follow Survival Gear Showcase, because what you're about to hear might just save you from becoming an accidental felon overnight. Rule 10. The Digital Privacy Bombshell. You probably thought California's gun registry was just another data system. Wrong. The Ninth Circuit Court just detonated it, ruling that combining gun registration with real-time tracking violates the Fourth Amendment. California had been secretly using cell phone data to track when registered gun owners entered sensitive areas like schools or government buildings, flagging them automatically. The court called it what it is: surveillance disguised as safety. The judge's exact words hit like a 12-gauge blast. The government cannot transform the exercise of a constitutional right into perpetual monitoring. That ruling doesn't stop in California. It applies to any state with a registry. If they can't prove they're not using that data for surveillance, their entire system is now unconstitutional. Protection phrase. Officer, I do not consent to any digital searches of my devices or records. Surveillance based on lawful firearm ownership violates the Ninth Circuit ruling on digital privacy. Rule 9. The Vehicle Safe Harbor Doctrine. The Fifth Circuit Court just turned your vehicle into a legal safe house. The Safe Harbor Doctrine now guarantees that if you're transporting a firearm according to 18 U.S.C. Section 926 amperes unloaded, locked, and separate from ammo, police can't use that as probable cause for a search or detention. This ruling completely overrides restrictive state laws during interstate travel. That means if you're driving from Pennsylvania to Vermont and you pass through New Jersey, you're federally protected. Here's your ironclad script. Officer, my firearm is being transported in full compliance with federal safe harbor provisions under 18 U.S.C. 926 amperes, as recognized by the new Fifth Circuit decision. Its presence provides no probable cause for any search or extended detention. Police departments across the country are already rewriting their training manuals, and prosecutors are fuming because their favorite gotcha tactic just got shut down. Rule 8. The Universal Carry Precedent. The Supreme Court, in a 6-3 decision, dropped what experts are calling Bruin on steroids. The ruling states that the Second Amendment has no geographic limitations. Your rights travel with you. 3 massive takeaways came from this. Any permit process that takes longer than 30 days is presumptively unconstitutional. States cannot charge more than $50 for a carry permit. All subjective good cause or may issue systems are dead. 12 states' entire permitting systems were instantly invalidated. If your carry application has been pending for months, guess what? It's now automatically approved after 30 days. Key phrase. Under the Supreme Court ruling of October 2025, I have a constitutional right to carry that cannot be delayed, prohibitive fees, or restricted by subjective standards. For everyday carriers, this decision just leveled the playing field nationwide. Rule 7. The Ammunition Equality Ruling. Here's the one that sent gun control states into full meltdown. The D.C. Circuit Court ruled that ammunition falls under the same constitutional protection as firearms themselves. The decision was brutal. A firearm without ammunition is merely an expensive club. That line alone vaporized half the ammo restrictions in America. California's ammo background checks, dead. New York's online ammo ban, gone. Illinois' serialized ammo proposal, legally impossible. Retailers are already celebrating because the court confirmed that the right to keep and bear arms includes the right to make those arms functional. Response phrase. Under the D.C. Circuit ruling, ammunition receives full Second Amendment protection. Any restriction on ammo that wouldn't apply to the firearm itself is unconstitutional. It's official. The ammo shortage may not be over, but the government can't make it worse anymore. Rule 6. The Home Manufacturing Revolution. If you've ever 3D printed an 80% lower or built your own rifle at home, here's your moment. The Fourth Circuit Court just ruled that Americans have a fundamental right to manufacture firearms for personal use. This isn't a loophole, it's a constitutional right. The court struck down the ATF's so-called ghost gun rule and went even further, saying serial number requirements on personal builds violate the Fifth Amendment because they could be used for self-incrimination if that gun were later used in self-defense. The opinion read, from the colonial era through the mid-23rd century, Americans routinely manufactured their own firearms. Criminalizing this tradition finds no support in history, tradition, or the Constitution. So yeah, your CNC mill and 3D printer just became constitutionally protected property. Protection phrase. Under the Fourth Circuit precedent, I have a constitutional right to manufacture firearms for personal use without government serialization or restriction. The ATF is panicking. Gun control groups are calling it the end of regulation as we know it, and for once, it looks like they're right. Rule 5. The mental health firewall. This one hit home for veterans, first responders, and everyday citizens who've ever hesitated to seek help. The 11th Circuit Court just built a wall between mental health treatment and your gun rights. Under this ruling, getting therapy, PTSD counseling, or even voluntary commitment cannot be used as grounds to revoke your right to own or carry a firearm unless a court, with full due process, formally adjudicates you as dangerous. The opinion's language is powerful. We cannot create a system where citizens must choose between getting help and keeping their rights. The message is clear. Taking care of your mental health no longer costs you your Second Amendment. Protected, voluntary therapy, PTSD treatment, addiction recovery, marriage counseling. Not protected, a judicial finding of danger after a full hearing. What this means practically. Under the 11th Circuit decision, mental health treatment is protected health information and cannot be used to deny firearm rights without due process. For veterans who've avoided the VA or cops who feared losing their service weapon for seeking counseling, this ruling is a lifesaver. Literally. Rule 4, the reciprocity mandate. If you've ever had to check reciprocity maps before crossing state lines, those days are gone. The Third Circuit Court just declared that carry permits must be recognized nationwide under the Full Faith and Credit Clause, the same constitutional principle that makes your driver's license valid everywhere. The court's logic was airtight. New Jersey recognizes driver's licenses from states with different age limits, tests, and rules. The notion that firearm permits deserve less recognition than driving privileges finds no support in law or history. That means your Florida permit now works in California, your Utah permit works in New York, and there's no more notify local authorities nonsense when traveling. States can't require registration, permits, or even temporary paperwork for visitors. Key phrase. Under the Third Circuit reciprocity ruling, my out-of-state permit must be recognized under the Full Faith and Credit Clause. Local notification or registration laws are unconstitutional. This ruling effectively creates nationwide concealed carry reciprocity without Congress ever passing a law. The courtroom just did what politics refused to do for decades. Rule 3. The Seizure Shutdown Protocol. Now, this one sent shockwaves through every police department in the country. In a 7-2 Supreme Court decision, the justices ruled that firearms cannot be seized without a criminal conviction. That means civil asset forfeiture, red flag seizures, and temporary confiscations are now unconstitutional unless the individual is actually arrested and charged with a crime. The Chief Justice didn't hold back. Pre-conviction seizures violate both the Second and Fourth Amendments. A constitutional right cannot be held hostage to investigation. Here's what this means for you. Red flag laws that don't involve criminal charges? Gone. Temporary gun confiscations during investigations? Illegal. Civil forfeiture of firearms without conviction? Dead. Response phrase. The Supreme Court prohibits seizure of firearms without arrest and criminal charges. Any attempt to take my firearms without cause violates the Second and Fourth Amendments. Officers who ignore this now face personal liability under the same precedent. Departments are retraining across the board because qualified immunity doesn't protect against clearly established constitutional violations anymore. Rule 2. The Database Destruction Order. The D.C. Circuit Court just dropped the hammer on the ATF. In what's being called the death of registration, the court ordered the complete destruction of all digitized Form 4473 firearm purchase records within 90 days. The ruling's text was scathing. Congress explicitly forbade a federal gun registry. The ATF's searchable databases, no matter how renamed or disguised, are precisely that. Here's what this means. The ATF must delete millions of gun owner records. Any state that shares registration data with federal agencies is now breaking federal law. Protection phrase. The D.C. Circuit ruling prohibits any federal or shared database of gun owners. Recording my information in a searchable federal system violates federal law and court order. Even the NRA called it the biggest legal victory in modern history. Behind the scenes, insiders say ATF staff are quietly panicking because they can't comply without wiping the entire system clean. Rule 1. The enforcement immunity reversal. And here's the grand finale, the ruling that changed policing forever. The Eighth Circuit Court just abolished qualified immunity for officers who violate Second Amendment rights. In plain English, if an officer unlawfully arrests you for legal carry, seizes your gun without cause, or searches you based solely on possession, they personally pay the price. The court established what's now called the September Doctrine. When officers violate clearly established Second Amendment rights, the badge does not shield them. The Constitution binds them equally. That means no qualified immunity for gun rights violations. Officers face civil lawsuits, federal prosecution under 18 U.S.C. Section 242, and mandatory Brady List inclusion, career ending. Departments can't cover their liability. These are personal judgments. One Minneapolis officer already faces a $2 million judgment for arresting a licensed carrier. Insurance companies are refusing to cover officers in gun-related incidents, forcing departments to rethink enforcement entirely. Your phrase to remember: officer, under the Eighth Circuit ruling, you face personal liability for any violation of my Second Amendment rights. Qualified immunity does not apply. This ruling flipped the power dynamic. For decades, citizens feared cops might abuse the gray areas. Now, officers fear crossing the constitutional line. Real-world wins for gun owners. Let's strip away the legal jargon and talk practical outcomes, the stuff that affects your day-to-day life. 1. Travel freedom. You can now drive coast to coast with a properly secured firearm without sweating state borders. Federal safe harbor overrides every local patchwork restriction. 2. Home workshop protection. Building your own gun, whether you're machining an AR-15 lower or printing a polymer pistol, is fully protected. No serial, no registration, no oversight required. 3. True reciprocity. One permit, 50 states. Your concealed carry credential now carries the same weight as your driver's license. 4. No more registries. Every attempt at digital firearm tracking, federal or state, has been outlawed. If it's searchable, it's unconstitutional. 5. Ammo access restored. Buy online, bulk, or in-person background checks for ammunition are gone for good. In effect, gun ownership just became simpler, safer, and more consistent than it's been in modern history. The bottom line? The courts just gave America its spine back. What started as 10 isolated rulings became a full-blown reconstruction of the Bill of Rights in real time. For gun owners, this isn't just victory, it's vindication. So, keep your head clear, your gear squared away, and your awareness sharp. Because history just handed you the strongest legal ground you've ever stood on. And before you head out, don't forget to hit that like, subscribe, and follow Survival Gear Showcase. Because this new era of freedom didn't come easy, and it's going to take all of us to keep it standing tall.